And a little bit trying to get the slides to.
You got it there. I had to grab that for a second to record. There you go.
All right. So I hope everybody's had an opportunity to review the fact situation. As Sandy said, it's quite interesting and was prepared by Larry Watson. What we're going to do today, both Rut and I, Rut is going to give you primarily the attorney, trial lawyer's perspective as a participant in the mediation process with regard to the ethical issues, and I'm going to give you the mediator's perspective. And the overall themes that we're going to be discussing today and dealing with in the mediation context are number one, protecting the process. What we have to do as lawyers, as mediators, to protect the mediation process. The second thing we're going to be talking about a lot is confidentiality, and confidentiality is kind of the cornerstone of the mediation process, and what I think makes it so successful. Thirdly, we're going to deal with the issues of misrepresentations during the course of the mediation process, and our overall theme is don't do anything to foster or condone misrepresentation in the mediation process. Next, the theme is promote self-determination. We all, as lawyers and mediators, need to, again, protect the process and promote self-determination. Now, what are the rules? What are our ethical standards and the references? For our lawyers, it's going to be the ABA Model Rules of Professional Conduct, the ABA Guidelines for Ethical Settlement Negotiations, and the Florida Bar Rules of Professional Conduct. For the mediators, it's primarily the Litigation Ethics Settlement Negotiations of the ABA, and then also the Florida Rules for Certified Court-Appointed Mediators. And also we have the MEAC opinions that are also posted on the dispute resolution website. Here's our fact situation. I hope everybody's had an opportunity to review it. It's a product liability case involving a user of a fertilizer product who was exposed to what is alleged to be the hallucinogenic qualities of the product. Here's the cast of characters from top to bottom who we're going to be dealing with in the fact situation. Off the bat, we've got issues with regard to accepting the engagement on the part of the mediator. In looking at the Section 1, accepting the engagement conflicts, you kind of wonder how it came about that Roy even got to mediate this case with all of the issues that came up at the outset. So what are the issues in terms of these are the rules, and what are the issues that we're dealing with in our hypothetical case? First of all, we have, if you look at your fact situation, Roy, through his retirement account, holds a mutual fund that holds stock in the parent company of Vibraflow or Vibragrow Fertilizer. Secondly, Roy and some of the defense law firm attorneys are friends, and they play golf together at the country club. Thirdly, Slippery Mutual, when Roy was in practice, used him before, and they admire his skills, and they are in the process of negotiating a preferred provider understanding with him regarding reduced fee concessions in exchange for volume referrals. And then lastly, Roy was actually a member of the defense firm, Blue Suit and White Shirts, and while he was a partner there, his firm actually did legal work for Fibergo.
Bob, can I interrupt you for a second, if you don't mind? We did have some person. We're not on the page anymore that has the link. Would you mind just go ahead and reading? Do you have that link in front of you? The name of the link for the fact pattern?
I can go back to it.
I'll go back. I just didn't. I'm sorry to interrupt you. There's one person who didn't get it, and I hate to do this, but I also don't like for people to be disappointed and not get what they need. So this is for. I'm gonna call them out. Looks like Al Torres. It looks like. Come on, Al. Let's get this. It's bit.ly/fact _scenario. So it's bit.ly/fact _scenario. So hopefully that will help him. And I am sorry for interrupting. I know that's disruptive.
My screen, this is Rutt, my screen, without my touching anything, went back to connected to GoToWebinar. So I've lost the slideshow.
Okay. I don't know why it did that. I think that somehow it minimized. I'm still on the right screen. Are you still on the right screen, Bob?
I am.
Okay. I think somehow it got minimized there, Rutt. Were you able to print out any copies of the PowerPoint presentation?
Yeah, I do. I have those, sure.
Okay, well, maybe we could just follow along using that, or just, you can mess around with your computer, at least trying to find it again. I just think it's minimized down on the bottom, Rutt.
Okay, well, I'll just work off my sheets.
Okay. All right, Bob, again, I apologize, but let's go ahead. And is this the slide that you left off on?
It is.
Okay.
Have you turned it over back to me?
No.
All right, I'm going to do it right now.
Rutt and I had quite a conversation about this, these conflicts while we were waiting to start. So I know Rutt has stuff to say.
All right, just looking at the rules, the conflict is defined as any relationship that compromises or appears to compromise impartiality. So disclosure is always the general cure. If you disclose it to the parties, then it's up to them to make a decision. And the burden of disclosure is, of course, always on the mediator. Well, let's look at what the problems are here. First, the mutual fund holdings. I think it's unusual that Roy even understands or knows that his retirement plan has the mutual fund holdings, but I don't see that as a real problem. It's something that could be disclosed, but I can't imagine the parties not waiving that conflict. The golf course connection, playing golf with some of the buddies in the defense firm. I don't really view that as a problem either. However, it's something that in a telephone conversation with the lawyers in the case could probably be disclosed. The third thing, which is the slippery mutual preferred provider arrangement, I view that as a real problem. I think that it's something that does or could possibly impact the mediator's ability to be neutral. It's something that I think should be disclosed, and it is something that is waivable. I think some people could argue that it is non-waivable, but I think for the most part it probably would be waivable. The last thing is the fact that Roy was a partner in the defense law firm. Again, that's something that should be disclosed by Roy, and it's something that since lawyers selected him on the front end, I'd be real surprised they didn't know about it in the first place, but it needs to be disclosed.
Bob, I was talking about this with Rutt, and we were talking about, they probably are waivable, but we were talking about which ones are just not acceptable, or which ones would really give you pause for concern. Rutt, which were the ones that as a litigator you would give you real pause?
Well, the potential relationship would give me the greatest pause, but I have to tell you that, I could see this being more of a concern from the mediator's standpoint than my standpoint as the trial lawyer involved. For this reason, I know the mediator. If I know the mediator and have dealt with the mediator over a period of time, I keep in mind that I control what my client does, not the mediator. The mediator can take what I say and take it to the other side back and forth. If I feel that the mediator at some point is showing partiality, then I can call the mediator's hand. But I'm not going to do anything that just because a mediator comes in and makes a statement. I'm going to do what I think's right, and I believe I control what the message is going back and forth. So that one concerns me the most, the past law firm relationship. Bob Cole mediates cases for me as does a lot of others here in town. Bob used to work with me as well as some others, and I don't see that as a problem. I really don't. If I trust the mediator, then I'm comfortable with it.
Also, you're getting all kinds of emails or information from our fellow attendees. They're saying if there is a blue or a yellow flower rut on your screen, click that, and that will bring everything back up. Do you see
I
it?
did, and it did. Thank you all.
Thank you, Beth Mills. You're a rock star.
Yeah, I thought it might explode when I did it, but it came back up.
No explosions here. I think the one that concerned me the most would have been the understanding with the other insurance company to have reduced fee in exchange for volume referrals. That one makes me a little bit nervous.
Yeah.
But
That is the biggest one for me, because I think that potentially impacts the mediator's capacity to be neutral. Or serve as a neutral in the mediation process. So again, we're talking about self-determination, full disclosure on the part of the mediator, and let the parties decide what they want to do with regard to the potential conflicts.
I just took the keyboard to take it back.
Okay.
I think I've got John Briggs who's kind of clicking in, and I think I can't see what he's saying because you've got the keyboard. I imagine what he's saying is there's a lot of background noise. So if you guys could be careful with the shuffling of papers, that would be great.
All right. And now we're going to statements about settlement. Section 2 of the fact pattern. And just to kind of summarize this, during the opening introduction of the day of the mediation process, Roy dutifully stressed the need for having the right players at the table to conduct the mediation process. Then later in the paragraph he says, Roy, during his opening comments, Roy specifically asked whether all parties have the required authority. All defense lawyers and the carrier enthusiastically assure Roy that they have all the settlement authority that they need. Later down, after the general session during the first caucus, Roy meets with Melody, the plaintiff's attorney, and she questions whether or not the slippery mutual representative has substantial authority, and she asks Roy to find out, and based on and not knowing anything about the authority, she makes a settlement demand of $9,500,000. Roy then goes and meets with the defendants, and during that conversation, the slippery mutual person says that they had a special claims committee evaluate the case. And he comes out and tells the mediator that they have put a maximum value of $500,000 on that case, suggesting to everybody, including the mediator, that there is some limit on the representative's authority, and that being $500,000. Then at the end, he goes on to say that we've got $500,000 on the case, and that getting any more money may possibly require the claims committee to convene again. And that, again, suggesting that there might be some delay in moving the settlement negotiations along, or something that would thwart the progress of the mediation. And then at the end, he says the plaintiff's attorney says, work to get the plaintiff's demand as low as possible, and then we'll take a break and make some telephone calls. So that's kind of the fact situation. The representative, the statement by the defense attorney about the $500,000 in authority probably should create some real questions here. In the mind of the mediator, he knows that he's looking at a $10 million, I think, pre-suit demand, and now he's looking at a mediation demand of $9,500,000, and he's being told basically that there's a limitation on the authority for $500,000.
Bob, I have a question. I'm sure you're going to get to it, but you know, where does the unreasonable demand come into play? I know we've talked about this with the new requirement for certifications, but inevitably a party comes in with an unreasonable demand, and the rules seem to require that regardless of the reasonableness of the demand, that's the authority that needs to be brought to mediation, and that just seems to be a bit of a disconnect.
Well, it is to a certain extent, but you know, we don't really, the rules don't get into the reasonableness or the unreasonableness of the plaintiff's demand. It's either the defendant is supposed to come with a representative with authority of at least up to the last demand, or policy limits authority.
Y'all there?
Yeah.
Yeah, Rutt, go ahead.
Oh, well, I completely, the little sign came up and said I'd lost audio connection, but I'm apparently back. I don't know what there may have been a pending question. Can I, if I may, let me address that from the trial lawyer's standpoint? Yeah,
I would love for you to.
All right. The first thing that I think everyone should do is, you know, pre-trial preparation, pre-mediation preparation is absolutely critical to a successful mediation. And I think you have to start with the process of finding out what information you have to have in order to proceed, such as send out the request for insurance information so that you know what you're getting under oath under the statute. And I mean, that is the first thing you do so that you know what you're dealing with, and that would be 627-4137. Now, when we look at the fact pattern itself, I think that the questions that Melody Maters raises gets things off to a bad start. I think it's a distraction, and it assumes bad faith on the part of the defendant. You know, after all, we have to remember that we start generally with extremes on both sides of the table. One wants $10 million or whatever it is, and one wants to pay $10,000. And you work toward, in the process, you work towards something that everyone can agree on. And I've heard people say so many times the best settlement is one where neither side is perfectly satisfied with the outcome. So I think if somebody came up to me, whether it be mediator or Melody Maters, outside the context of the mediation, and asked me about my authority, I would tell her I'm here in good faith, and that's all you need to know. Let's get the process going. And I don't think she is entitled to know what my authority is, nor do I think the mediator is entitled to know my authority. I'm here to mediate in good faith, and let's get the process going.
I don't think the mediator wants to know the authority, at least I don't. I like not knowing what the authority is, and I think the whole idea of the new rule was to take the mediator out of that conversation. I don't know that it's happened in truth and in fact yet, or in practice yet. Bob, what do you think?
Well, I think that it's, you know, it's a very small percentage of the time does the defense attorney or the defendant ever tell me what their authority is. Most of the time they don't want me to know what their authority is. But sometimes they do, and sometimes I find it helpful because I can then kind of staged the negotiations, and I know, at least from the defense side of the thing, what their authority is and what their target number is for the negotiations that day.
Okay.
You know, I was looking at one question that one of the participants sent in and said, what if we can settle the case for less than the adjuster is willing to offer? I would say on the defense side, for goodness sake, settle it. You've just saved your client some money if the plaintiff is willing to take it. And on the other side, if you, on behalf of the plaintiff, can get more than the plaintiff has said, this is what I want, then good for you. Go for it and get as much as you can. I don't see any problem with that whatsoever.
All right. Going through the model rules, let's see. We get to confidentiality, the statements about settlement authority. And here, you know, we're talking about the defendants disclosing to the mediator that they only have $500,000 in settlement authority, and that to get any more money, they have to make telephone calls or possibly even reconvene the claims committee. But that's something the mediator keeps to his or herself, and there's really no need to even get into that, but it's all protected by confidentiality. And again, it's the mediator's responsibility to do everything he or she can to safeguard the mediation process and proceed accordingly. That takes us to the statements about insurance coverage. In the fact situation, it's Melody's belief that Slippery Mutual has a $500,000 CGL policy. And during the opening presentations, Melanie tries to confirm that belief by a direct question to Bill Billum, the defense attorney. And Billum indignantly responds to Melody's inquiry by saying, as insurance counsel, I don't get involved with coverage discussions, and I'm not in the business of revealing my client's private contractual business affairs. You are correct, however, that there is a general liability policy here with $500,000 limits. In light of that confirmation, Melanie reduces her demand from the $9.5 million to $4.95 million to bring it within the policy limits. Then Roy goes back and meets with the defense folks, and he's talking to Bill about the demand. And Bill tells him, perhaps I should be just a bit clearer about the insurance situation. There is a base policy of $500,000, but there is also an umbrella policy with another $500,000 in coverage. Slippery Mutual has raised major objections inserting coverage under either policy, and Vibra is at odds on these coverage issues. Now, here we have a complete misunderstanding by the plaintiff's attorney and the plaintiff about the insurance coverage. Rhett, what do you think about this, and from the mediation standpoint, the mediator's standpoint?
Well, you know, again, it gets back to Ms. Mater's doing her workup in an appropriate, thorough fashion. I think that these issues should not necessarily even be raised in the course of the mediation if, pursuant to 627-4137, she had made a demand for a statement under oath as to what the policies that may have existed were, what the limits, whether there's a primary, whether there's a self-insured retention, where they plug in, whether there's an umbrella or excess coverage. so that going into the mediation, you know exactly what's out there. A lot of it depends on how serious the injury may be, but I think that the lawyer for the plaintiff always has to take into consideration the possible bad faith exposure of the insurance company. In that regard, you need to know what the policy limits are, especially in a serious case, or especially when the policy limits are low, 10,000, 50,000, 100,000, so that you can make a demand early on for settlement within the policy limits, and in the event of the failure to settle a case, you have preserved your bad faith cause of action against the insurance carrier. So this back and forth about, what are the, if it gets to this particular stage, and Melody has not done her homework to prepare herself for this point in the case, and the question is point blank asked to the attorney for the carrier, well, I don't think he can misrepresent what those particular limits are. I think you have to come clear with it. I mean, if you look at what I've tried to do for the sake of the participants, and I know we talk about the ABA code, model code, I've tried to translate that into the Florida rules of professional conduct. And when you're talking about misconduct, it's 4-8.4, and when you're talking about misrepresentation, it's 4-4.1 of the rules of professional conduct regulating Florida lawyers. So take a look at those, and if you look at the 4-4.1, it says that in the course of representing a client, a lawyer shall not knowingly make a false statement of material fact or law to a third person, or fail to disclose a material fact to a third person when disclosure is necessary to avoid assisting a criminal or fraudulent act by a client unless disclosure is prohibited by 4-1.6, which is client confidentiality. Now, let me tell you how I've seen this come up on occasion, and I would say that oftentimes it is an honest mistake where there is an underlying policy and that followed by an excess policy, and people, when they disclosed insurance, they forgot about the excess. I always suggest that people in your release, if you settle on the basis of your belief that there's a 100,000 policy, when in fact it's a lot more than that, and that you include in your release language that you're relying upon the representations as regards insurance coverage and otherwise as being true, so that if you find out later that there was a misrepresentation, whether intentional or unintentional, you can set it aside for fraud and go back and start the process over again because they withheld information which forced a settlement that you would not otherwise have entered into.
You know, Rhett, you just hit the nail on the head with one of the questions that we got about misrepresentation, which I think is a great question. I'm going to present it to you all, if you don't mind. It says, last month we had an insurance company lawyer outright lie about the policy in a mediation. We got it in discovery, but the defendant insisted it was half that at the mediation and came with only half authority. After it blew up the mediation, the court questioned the adjuster under oath, and he admitted the lie. But guess what? There were no consequences for his lying. What should the consequences be? I think what you've just said is genius, and that is put it in the release so that you're not bound by it, and then go back and chase it later, I guess.
Yeah, I have seen cases reopen where there was a settlement for $1 million, thinking that was the extent of the policy limits, only to find out that there was an excess policy for another $1 million. And if you've handled the case properly, I think you can have it set aside, in my opinion, on the basis of fraud and misrepresentation. Now, as to the particular question you have there, what do you do if you find out later? It depends on I would guess whether the insurance adjuster has misled the lawyer in terms of how much the policy is, or whether the lawyer knows that it's more than stated and withholds that information. If the lawyer engages in a misrepresentation, and as we discussed about under either a misrepresentation or 4-4.1, where you shall not knowingly make a false statement, then I think the lawyer has committed an infraction of the rules of professional conduct, and I believe that that can and should be reported. As to what the insurance adjuster may have done, you could also seek sanctions in connection with the mediation process, because if it occurs, if you find out during the course of the process, I would just say, adjourn this mediation until I get appropriate advice and I get a degree of honesty in terms of disclosure.
Getting back to the mediation process and moving this mediation along, where we've got the plaintiff's attorney is under the impression there's a $5 million policy, and the mediator's now been told that it's not $5 million, there's actually $10 million because there's a $5 million excess. Clearly by rule, the mediator is prohibited from revealing that because of the confidentiality requirement. But I think one thing that could be done in this circumstance is that, if it really and truly is a catastrophic case, and it's arguable that the damages would exceed the $5 million in the CGL policy, I think the mediator would probably be well advised to get the defense attorney out of the room, talk to him or her and say, listen, the plaintiff's attorney is under the misimpression that there's only $500,000 in coverage. This is something that needs to be straightened out, and I would encourage the defense lawyer to get the plaintiff's lawyer out in the hallway and go ahead and lay the cards on the table and disclose what the effective coverage is.
If I may, Bob, let me address looking at, again, about the statements about insurance coverage where Billum tells Roy, perhaps I should be just a bit clear about the insurance situation. And at that time, he raises issues concerning coverage under either the policy and Vibroglow. There's considerable odds with them over coverage issues. And if I'm representing the plaintiff, I'm not really concerned about what internal conflicts the defendant and its carrier may have. If they have coverage issues, they are there to participate in mediation, so it would appear to me that they're there to, hopefully in good faith, try to arrive at a settlement. So I don't care whether they have coverage issues or not. If they're willing to pay my number, then those coverage issues are subsumed in the settlement. So I don't care about the coverage issues. I just want to proceed with the mediation. And if they'll pay what I want, I'm satisfied.
All right, that takes us to the next section, substantive facts. In looking at the narrative, the first issue we have here in substantive facts versus negotiating position is the notice issue on whether or not the defendant knew that Vibroglow was an hallucinogen. And in the pleadings, the defendant has vigorously denied that it's an hallucinogen. And interrogatories were propounded asking the company if it knew of the hallucinogenic properties, but the answers given were inconclusive. Here the interrogatory answers are basically no answer. It's essentially an objection. And in a caucus with the plaintiff, Roy is asked by Melanie to get a straight answer on the notice issue from the defense. Roy, she says, I want you to find out if the company had any idea one could trip out on TurboTrip. And then with that request in hand, Roy goes back to the defense room, and he's talking with the Vibroglow representative, and is told that just yesterday he learned that his plant supervisors frequently caught employees copping a buzz during lunch hour by smoking TurboTrip and a bong. And Vibraglow's lawyer, Betty, is shocked by this revelation. It's news to her, and she quickly tells Roy, you are not to repeat that information to the plaintiff. In wake of this news, the Slippery Mutual representative makes a call to the home office, and they reevaluate the case. And now he discloses that he now has $2 million in settlement authority. But as a negotiating ploy, tells Roy, "I want you to tell them we're offering a cool $1,500,000. Tell them that's how we evaluate the case, and that amount is the maximum of our authority. Our hands are tied." 10 seconds later, he goes in the room with the plaintiff, and he specifically asked, what have the defendants said about the prior knowledge issue, and how have they evaluated their case, and what is their authority? So those are questions that are being posed to the mediator. First of all, the question about go to the plaintiff's lawyer asking the mediator to go to the defense room and find out if they have any idea about the notice issue. I know we've got a lot of mediators here participating, and that's something that I just don't think it's appropriate to for the lawyer to be asking the mediator to go in and find out what the evidence is, or what the company's knowledge was about notice. Rutt, what do you think about that request from the plaintiff's attorney?
Well, I mean, you can request anything and see if you get anywhere with it, but let's look at the pleadings. It says, in the pleadings, Vibrago vigorously denied TurboTrip as a hallucinogen. That tells me that the plaintiff must have had some information that it could produce hallucinatory side effects, because there must have been an allegation in the complaint to that effect, or else they would not be denying that it is hallucinogenic. So there is some knowledge going into the process. I see no harm, no foul in trying to get that information from the company, but if you feel that your case is not strong enough, then maybe you should declare an impasse and we'll go back and do further discovery. I'm assuming that the plaintiff has taken the critical depositions of individuals to determine whether or not there was any knowledge within the business itself as to the hallucinogenic effects of this particular drug. Again, you get back whether or not, and I agree with you, Bob, I don't think that the mediator should be used as a tool for discovery in the process. I would think, I've got my certification as a mediator too. If I thought there were a problem between both sides, I might put them both in a room and say, y'all sit down and talk about this outside of the presence of the mediator. Ask your questions, whatever you want to do, and see what you come up with. But not with a mediator involved, if you feel that this is something that is appropriate at that time. I mean, I've had situations where I have counseled with opposing counsel in the course of a mediation just to address some particular issues. I don't see any problem with that.
What about the situation here where the defense lawyer has answered an interrogatory from the plaintiff and either signed the interrogatory answer himself or herself, or had the client sign the interrogatory, and now in the mediation conference he's finding out from his client that they had actual knowledge of the fact that employees were abusing this product, and it in fact is an hallucinogen, and they had knowledge of it?
Well, that's kind of a tough situation to deal with. I don't have the rules of procedure in front of me, but as I recall, unless there's a pretrial order or something to that effect, that there's not necessarily a requirement that you continually amend your answers to interrogatories. Now, if it turns out that your first set of interrogatories were intentional misrepresentations, and I hear you say he just learned about it, that may alter the playing field to some extent. But when I see it looking, it says in the wake of that news, this lawyer says they made a call to the home office and reevaluated the case, and we now have $2 million in settlement authority. As a negotiating ploy, I want you to go back and tell him we're offering a cool 1.5. That's after he stole the mediator. He has $2 million. I've never encountered personally a situation where there was information that of this effect, which could potentially even lay the groundwork for a punitive damage claim, depending on how it developed. So I think that if the settlement offer suddenly jumped monumentally, I would wonder what caused that to move to the next level. And I would want to ask some questions, but I think I would want to do it personally and not let the mediator be the message carrier.
All right. Here we're back to the confidentiality. The mediator is now told during a private caucus that they did have knowledge of this, what does the mediator do about gaining this new knowledge? My thought is that the mediator should keep it to himself. I think that the approach on this, even though the plaintiff's attorney has specifically asked him to go find out what the answer to the question is on the notice issue and to explore that, I think what the mediator needs to do is to work on the defendant and defense counsel from the standpoint, well, you've now told me that you've learned through supervisors that supervisors, employees are abusing this product. If they know about it, then other employees know about it, and both current and former probably. So you need to rethink your position on whether or not you can defend the notice issue, and that should bear directly on how the settlement negotiations proceed.
Was that thunder in the background?
It is here in Jacksonville, yeah.
Wow, that was crazy.
Bob, let me add this. I think this is something that the litigators and the mediators need to take into consideration. It happened to me a few years ago, where we had a lawsuit that was filed here in Jacksonville, and the mediator was the magistrate was selected by the judge to actually mediate the case, which I never had happen before. And we mediated it until like 2 in the morning and settled it. But would Mr. Billum act differently if the mediator was a United States magistrate or an active judge who had been requested by the chief judge because the severity of the case is step in and mediate now? In this case, this was an active United States magistrate who actually picked the jury during the course of the mediation. We mediated one day, then picked a jury, then mediated on a Saturday until 2 o'clock Sunday morning and settled. But I think lawyers have to be real careful what they say to mediators. Realize, settlement is posturing, but settlement should not involve misrepresentations. And you might find be on the wrong side of the law, especially if you lied to a mediator who was also a United States magistrate.
That takes us, again, under the substantive facts versus negotiating positions, the question about self-determination. We've talked about, the coverage issue and, getting the plaintiff's attorney and the defense attorney together to straighten out any misconceptions about insurance coverage. We talked about the notice issue on whether or not how that should be handled in terms of misrepresentation. And then lastly, I think we've got the case evaluation issue about, how the the defense attorney and the defendant are evaluating the case. But in looking at this, the mediator has to be bound by confidentiality. The mediator cannot take an active role in communicating any misrepresentation, and he has to do everything that he or she can do to promote self-determination on the part of the parties. Talked about, let's see, adjournment or termination by the mediator. Let's go back to the insurance coverage issue, and let's say that the mediator is very concerned about the fact that there's a misunderstanding about the insurance coverage. You talk to defense counsel, and defense counsel refuses to straighten the issue out. He or she says, well, we've answered interrogatories, or they didn't do a request for the insurance information pursuant to the statute, and I'm not going to go in and I'm not going to talk to the plaintiff's attorney about the coverage issue. What should the mediator do? Should the mediator adjourn or terminate the mediation? I think in this instance, if we assume that that damages could possibly exceed the $5 million of the underlying coverage, I think this is a situation where the mediator might consider adjourning the mediation conference so that the insurance coverage situation can be straightened out. What do you think about this? Given your background and experience in bad faith litigation, what do you think about adjournment or termination?
Well, that certainly would be one solution. On the one hand, you can't have two fiduciary obligations. If I'm representing the defendant, my fiduciary obligation is to the defendant. If I'm representing the plaintiff, it's to the plaintiff. You have to assume that what has occurred in terms of discovery went forward with intent. That is, that the plaintiff requested the information, and then I gave the information in response to discovery in an honest fashion. If the information I gave was what I thought was correct, and it ultimately turns out that I had misinformation, whether intentional or unintentional, I think I do have a duty to disclose that in order to proceed in the appropriate fashion. You don't want a tainted settlement, but I don't know that if you adjourn, what's next? I mean, the plaintiff may wonder, well, why are we adjourning, unless somebody says, go back and make another request under the particular statute for additional information, or says you don't have all the information, which I don't think the mediator has any business giving. You look, when I saw one question from Winter Park says, what to do when you see malpractice by counsel, my immediate response was, be thankful it's not you. Because the malpractice can occur, and as long as you have done your job and have been forthright and disclosed and not misrepresented anything, you're not your brother's keeper in litigation. And so I think the thing is to continue the process, but if the plaintiff's demand is based upon a belief that there's a certain policy limits and they're trying to posture for bad faith, then you can have a serious problem.
Okay. All right. Negotiating positions of the lawyers, right? The negotiating positions and the statements of material fact by the defense counsel. What do you think about negotiating positions versus substantive facts?
Well, I think, obviously, under the rules regulating our profession, you cannot make a misrepresentation. But again, mediation and settlement negotiations, with or without a mediator, it's posturing. It's an attempt to do the best you can for your client. And the thing you don't want to do is misrepresent the essential facts in order to gain an advantage. I think I would not misrepresent something. I would simply avoid discussions about it and just say, look, we believe our case is defensible. Here's what we're willing to pay, and see what happens. Let it go from that standpoint.
What if the defense attorney makes a comment something like this? As God is my witness, Slippery Mutual will never pay any more than $1.5 million on this case.
If that were communicated to me as plaintiff's counsel, I would laugh and would not. I would continue the process as if that comment were never made. I think that's rather little league for him to make a comment like that. I wouldn't pay any attention to it.
You know, I'll add one thing from the perspective of a newer mediator, and that is, you know, we all know that there's a lot of negotiating, posturing going on, but at some point you need to build a rapport with your mediator so that they know when you are at your bottom line and when you're not. I have impassed mediation because I was told under no uncertain circumstances that the money on the table was all that was coming, and I let a party leave because I was told that over and over and over again. And when I went back and said we've impassed, the other party has left and they're frustrated, I was you know, scolded for why'd you let that happen. And I said, well, we discussed what your bottom line was. You told me this was your last and final, best and final, whatever, and I believed you. Okay. So if that wasn't the case, then don't play games with your mediator, I guess, is what I'm trying to say.
Yeah. And is this rule right here, model rule 4.1, specifically says estimates or price or value and a party's intentions as to an acceptable settlement of a claim are in this category. Here, this is posturing and negotiating positions.
Is the world ending in Jacksonville? It sounds like there's quite the storm up there.
It is.
Well, I can't see the buildings across the street. Bob and I are 4 floors apart, looking in the same direction, and I cannot see. I cannot see across the way.
Hey, that is quite a storm.
Yeah, it is.
It is. We have mushrooms in our yard.
So here we have the role of the mediator with regard to communicating negotiating positions. You know, as a mediator, you know, I'm really sensitive to, you know, what people tell me, and then what they tell me to go into the other room to communicate to the other side. And I think all of us as mediators have an obligation not to either intentionally or knowingly foster any misrepresentation during the negotiation process. And the obligation is the same for attorneys.
I agree.
And here's the question: does a state of mind or posturing regarding settlement evaluation rise to the level of a statement of fact? And I just don't think it does. I just don't think it does. There are some other questions. We hear it from time to time in mediation, where the mediator, and Rutt, you've probably heard this coming from the mediator from time to time. What about this statement from the mediator as to negotiating positions? It looks to me like that's all the money they've got on the case. Trust me, you're not leaving anything on the table if you take this offer.
As a mediator, I would not make that statement.
I would never say that either. That's, yeah.
I don't think any mediator would. And
in my opinion, Bob, you know, or you get a pretty good idea, because I've done it, is when you see me packing up my briefcase and walking towards the elevator, you've got all I'm going to offer you. And that might send a message to you that that's it for the day unless you can show me some better cards.
What about this statement? Well, I'm being told that is the maximum they will pay.
I've said that before, because that's what I'm told. I mean, if they're ready to walk out the door,
told, and you're communicating a factual statement.
That's what I have said that many a time. Yes, I don't like saying it. I'd prefer avoid saying that. But if that's the case, I've got to be honest with the other side.
What about this statement? The noises coming out of their mouths seem to be trying to say that's all the money they will be offering.
I think that's just cutesy. I don't do cutesy in mediation.
All right, let's go.
I actually have concern for you all. Are you safe?
Oh, we're safe. Yeah, I've got a lightning rod in my head. We're good.
You guys are getting tons and tons and tons of input and discussion, and you're going to have fun after this seminar, webinar, following up with some of these comments you're getting.
All right. Well, that takes us to the next section of our hypothetical case, dealing with legal advice, legal information, and malpractice. Melanie Matters confides in Roy that she just realized she clean forgot to include a count in the complaint against Vibroglow for a violation of the state's stringent Truth in Fertilizer Act. And if she had asserted that claim, that would allow the plaintiff an opportunity to collect attorney's fees and generous statutory penalties. And of course, Peter thinks he's got the greatest lawyer in the world and makes that known to Roy. Meanwhile, back in the defendant's room, a bitter argument has developed over the coverage issue relating to the pollution exclusion in Slippery Mutual's policy. The insured, Vibroglow, is asserting that the exclusion doesn't apply to this case, and of course the insurance company is taking the opposite position. Roy, by virtue of his past experience, is a walking encyclopedia on excluding pollution form insurance coverage and can decisively advise both sides of the legal shortcomings in their argument. If Roy doesn't say something soon, it seems clear that the defense camp will freeze up the negotiations, quibbling about this issue. So the question arises, should Roy inject himself into, in terms of communicating some of these issues? And again, we get back to self-determination. The mediator should not make substantive decisions for the party. The mediator is responsible for assisting the parties in reaching informed and voluntary decisions while protecting the right of self-determination. The first issue is, does the plaintiff need to know about his lawyer's malpractice in order to make an informed decision about whether or not to settle the case for what's being offered? Rut, how do you weigh in on this lawyer malpractice issue?
If you played it out to its bitter end, yeah, it could be a malpractice. But look, you're at a mediation at this particular point in time, and when she says, "I clean forgot," that means she now realizes that's when you can amend your complaint under a situation as that. And if she felt that this was a threatening situation, she could tell the mediator, look, I need to amend my complaint, and so I think we need to stop the mediation, adjourn. We can come back at a later time. On the other hand, you can tell defense counsel that I intend to amend my complaint to include the Truth in Fertilizer Act as a specific cause of action, so that they can be aware of this now, and maybe we don't have to come back. So I think the disclosure in that regard would not be inappropriate and might avoid the process of amending the complaint and coming back later for the completion of mediation.
And of course, that would be a discussion that the mediator would have with the plaintiff's attorney outside the room in the hallway,
Yes.
away from his or her client. That takes us to the second issue, which is Roy's experience on the coverage issue and the pollution exclusion. I feel a little bit differently about this issue. You know, I think that it's the role of the mediator to sometimes challenge people when they take a position on legal issues, not to the level of giving legal advice, but just getting it out on the table. And I know lots of times in mediation we deal with coverage issues. Sometimes we have the defendant, we have defense counsel, and then we have someone from the insurance company that's handling the coverage dispute, and then we also have separate coverage counsel. And sometimes I actually find myself conducting a mediation within a mediation. And I think it's helpful if the mediator has a special expertise in that area of the law, then I think, you know, it's helpful to share that experience. You're not really telling the parties how a judge is going to rule, but you're kind of laying out what the potentialities are.
Bob, I agree with you. I think that I don't like mediators who simply carry numbers back and forth and are what I would call messengers. I like a mediator who is going to challenge my position. More importantly, I want the mediator to challenge it so that my client can hear it and make decisions based upon being truly informed. And the way you do that is, I think, by saying, listen, have you thought about this? Have you thought about that? And what are your thoughts about this? You don't have to make an opinion or give a legal opinion on whether there is or is not coverage, but I think it's designed to make them think about it.
All right.
We have about 10 minutes left, Bob. I know you're doing a good job pacing. I just wanted to give you an update.
Yeah, I'm trying to go through these slides here. And here we've got, you know, providing information, which I think is consistent with the mediator's role in being impartial in sharing information that will assist the parties in making their own decision. I think providing opinions is a little bit different. Obviously, the mediator shall not opine how the court will rule on a particular issue, but I don't see anything wrong with a mediator sharing his or her past experience in how the judge or judges in your jurisdiction might rule on a particular issue. And again, the role of the mediator is to facilitate the opportunity to get the case resolved. And it's the mediator's job to assist in that endeavor by providing relevant information. And this takes us back to the coverage issue and the pollution exclusion, and I think it's important for the mediator to get involved in that process, assisting the parties to facilitate a resolution of the case.
You know, especially in bad faith cases, the insurance carrier is going to be right in the middle of that. And I think a question you ask, depending on the litigation, is ask the defendant, how do you think a jury is going to receive this type of information? I will tell you from first-hand experience that having taken 5 days to pick a jury one time in a coverage case, jurors do not like insurance companies. They feel if they pay a premium, the insurance carrier should cover it, whether it's covered under the policy or not. So there's a built-in prejudice against insurance companies from my standpoint.
All right, this takes us to the last section of our fact situation. Here we've got pretty much got an agreement on what the number is, the monetary terms of the settlement, and at the last minute, the defendant starts throwing more issues into the mix. And the slippery mutual lawyer starts talking about, hey, we're paying these folks a lot of money to resolve this case. We want a commitment from Ms. Maters that she and her law firm will refrain from bringing toxic tort, delusions of root and vegetable syndrome claim against thee in future. So here they're asking the mediator to go back and secure an agreement from the plaintiff's attorney that they're going to drop this litigation, not take any other cases. Also, the VibraGlow representative starts talking about confidentiality issues, and he says we don't need this word of this concession spread over the producers, the fertilizer producers community. It will raise a stink with our stockholders, not to mention those pesky USDA inspectors. We want Melody off the market, and we want a strict confidentiality clause. Roy goes back to the room with the plaintiff's attorney, talks to the plaintiff, talks to Melody, talks to Peter, and he's relieved to learn that there's no immediate objection to these requests. Peter, however, says he needs to get out of there, that he's got a hot date with a Vegomatic and wants to go home. He's obviously having one of his moments and appears totally unfocused with regard to what's going on in the mediation conference. Right, here we've got a request from the defense to ask the plaintiff's lawyer to get out of the litigation. Tell us about that.
Well, if you look to Florida Rule Professional Conduct 4-5.6, that specifically deals with restrictions on the right to practice. And it says, a lawyer shall not participate in offering or making an agreement in which a restriction on the lawyer's right to practice is part of the settlement of a client controversy. And if you go down to the comment, it says subdivision B prohibits a lawyer from agreeing not to represent other persons in connection with settling a claim on behalf of a client. So it would appear that by rule that this is impermissible to ask for or give such an agreement. Now, notwithstanding, I've seen it happen, and I've seen the situation a few years back where the defense, in order to get these lawyers out of the future cases, cut a side deal to pay the plaintiff's lawyers money for that promise, and it was never disclosed to the client. I think those lawyers had some very serious problems. As to confidentiality of a settlement amount, I don't have any problem with that. And if some people want to post that they got a big settlement from XYZ, You can negotiate a deal where you can put the amount of the settlement in, but not name the person you got it from, or the amount, the amount, which usually is, in the Florida Jury Reporter, you see a lot of those where they don't name the defendant that they got the settlement from, but they name the amount of what the settlement was.
And in this instance, both the plaintiff's lawyer in asking for the agreement that the plaintiff, the defense lawyer, asking that the plaintiff lawyer get out of the litigation, and the plaintiff's lawyer for agreeing to it, they'd both be in hot water from an ethics standpoint.
Yes, according to the rule, and in my conversations with bar counsel, yeah, it's not permitted. You can see, if you developed, you can see the horrible things that could happen with regard to limiting your access from other people who wanted to engage you as a lawyer. Not to mention the possible problems where the settlement was enhanced in order to buy you out of future litigation by giving you a little sweetener on the side or adding money to the case. I don't even think this is something that should be shared with your client, I'll be honest, because the client may say, well, God, they offered me $5 million, now they're offering me $6 million for you to stay out. Take the $6 million and stay out. I think you've got a problem there too.
Well, let's say, Rutt, that you're the plaintiff's attorney and you agree on a number. The defendant says we'll pay $5 million to settle the case, and but we want you to get rid of documents, the discovery that you got, and the depositions that you may be under seal, or the company documents that you got. We want you to. We don't want you to share that information with any other lawyers. We don't want you to contact the Food and Drug Administration. And if you don't agree to that, we're not going to settle the case. What do you do there?
Well, that creates considerable heartburn because what if it involves a very dangerous product, and they ask you to destroy or conceal discovery that could prevent another serious accident in a situation like that. Nevertheless, you'd have to look to whether or not, in the course of litigation, that discovery was made available to you pursuant to a court order that contained confidentiality requirements, which I see all the time, which at the end of the litigation it says that all the documents must be returned to the producing party. So if you've got a court order that says return them, that's fine. But I would want to, if I got into a situation like that and it involved public health and the well-being of our citizens, I would want to, I might say, if we don't have a confidentiality agreement or a return document agreement, that I suggest, so that it takes it off my shoulders and I can never be accused of wrongdoing, that you get the court to give you an order to that effect. And I would also contact the bar's hotline for an informal opinion as to my obligations, so that I was not was complicit in some wrongful act.
All right. Well, that takes us to the last slide, which is basically the right way to do the right thing. And it's obvious through our fact situation in this discussion that the mediator and the lawyers need to ask the right questions. You need to be knowledgeable about the ethical rules and the code of conduct, so you can make the right decisions, and you need to be able to steer clear of trouble and avoid the shoals, and so that you can effectively and ethically represent your client's interests, and from the mediator standpoint, mediate cases, reach agreements, and that will be that will hold up and not be contested. And lastly, always ask the question, what would your mom want you to do?
My mom always says, "Take the high road," and it's probably the best advice I've ever gotten. So if you always take the high road, then you're always on the right path. So Bob and Rut, you guys did a great job with the heavens opening up in Jacksonville and a couple little tech glitches we had at the beginning. But I want to thank you both. We have a ton of follow-up questions that I'll be providing to you, including several from some mediators here at the firm who are learning from you, which is why Upchurch, Watson, White, and Max is such a great place to work, is that we have such great colleagues that we really can bounce ideas off one another and really make this a learning process for all of us. I hope you all enjoyed our webinar today. We do have several more coming up in the series. We have a webinar coming up in October that is being hosted and presented by Brandon Peters and Michelle Jernigan of our firm. That is on October 23rd. On November 18th, Chuck Mancuso from our firm will be offering a webinar. And early in December, Judy Bass, one of our South Florida mediators, will also be offering a webinar. So look for the information about those on our website at www.adr.com. Let us know if you have any topics that are of interest to you that are ADR related. We will get those up and running for you. And I want to thank all of you for attending today. We had about 150 attend, about 200 sign up because life gets in the way sometimes. We hope that you all will send us some future topics, and if you are not on our list and would like to be, please email Kathy Klasny, cklasny@uww-adr.com, and she will get you the information that you need. Our CLE number for today is 1406439N. This will also be posted on our website for you to listen to at your leisure, or you can refer your friends to it to get some free CLE. This is 1.5 hours of CLE credits, including some ethics, which is sort of hard to get. So this is an awfully convenient way to get that ethics credit out of the way. Thank you to the University of Florida Levin College of Law Institute for Dispute Resolution for sponsoring with us again today. And from all of us here at Upchurch, Watson, White, and Max, on behalf of Rhett Lyles and Bob Cole, I wish you all a wonderful afternoon. Drive safely. Stay out of that rainstorm up in Jacksonville. And from all of us here, we say ciao for now. Thank you. Bye, everyone.
Bye-bye.
Thank you, Sandy.
Thanks, Sandy.